Hi, I'm Garth Drinkwater from Small Business CGT Concession Specialists. In this video, I'm going to talk to you about connected entities and affiliates. Particularly, I'm going to talk to you about the relevance of connected entities and affiliates, when an entity might be an affiliate, when an entity might be a connected entity, and the special spouse or child under 18 affiliate rule. I'll start with the relevance of connected entities and affiliates. There are many basic requirements which need to be satisfied by an entity to gain access to the small business CGT concessions. These include either the CGT Small Business Entity Test or the Maximum Net Asset Value Test, as well as the Active Asset Test. Each of these tests refer to connected entities and affiliates in some way. I've just talked about the relevance of connected entities and affiliates. I'll now talk about when an entity might be an affiliate. An affiliate of an entity can only be an individual or company which carries on a business, and only if the individual or company acts or could reasonably be expected to act in accordance with the entity's directions or wishes, or in concert with the entity in relation to the affairs of the business of the individual or company. Now there's a lot in that, so let's break it down. Firstly, an affiliate can only be an individual or company. So this excludes partnerships, trusts and superannuation funds. And trusts and superannuation funds remain excluded even if they have an individual or company trustee. Secondly, to be an affiliate, the individual or company has to carry on a business. If it doesn't, it can't be an affiliate. Thirdly, to be an affiliate, the individual or company has to either act or reasonably be expected to act in accordance with the entity's directions or wishes in relation to the affairs of the business of the individual or company, or two, act or reasonably expected to act in concert with the entity in relation to the affairs of the business of the individual or the company. So for both of these requirements, the actions are undertaken by the potential affiliate in relation to their business, based on some kind of influence from the entity, or we're working together with the entity. But this doesn't extend to cover actions that are undertaken merely because of business relationships that might be shared. For example, partners in a partnership or directors in a company would not automatically be affiliates. The factors that are generally considered when assessing whether potential affiliate relationships exist include whether there are close family relationships between the parties, whether there are any formal agreements or relationships between the parties dictating how the parties are to act in relation to each other, whether the way the parties act in relation to each other would be based on the relationship between the parties rather than based on formal agreements or legal or fiduciary obligations, and the actions of the parties. I've just talked about when an entity might be an affiliate. I'll now talk about connected entities. Entities are connected with each other if either entity controls the other entity, or both entities are controlled by the same third entity. The test for whether an entity controls another entity depends on the type of entity being controlled. For companies, an entity should control a company where the entity and its affiliates own interests in the company that carry rights to at least 40% of distributions of income, distributions of capital, or voting power. For unit trusts, an entity should control a unit trust where the entity and its affiliates own interests in the unit trust that carry rights to at least 40% of distributions of income or distributions of capital. For partnerships, an entity should control a partnership where the entity and its affiliates own interests in the partnership that carry rights of at least 40% of the net income of the partnership. For discretionary trusts, an entity should control a discretionary trust where either the trustee of the trust acts or could reasonably be expected to act in accordance with the directions or wishes of the entity and its affiliates, or the percentage of income or capital that has been paid or applied to the entity and its affiliates is at least 40% of the total income or capital paid or applied by the trustee in any one of the 4 years immediately before the relevant tax year. If the entity has a control percentage in another entity of 40% or more, but less than 50%, the Commissioner has a discretion to determine that the first entity does not control the second entity, but this will only be applied if the Commissioner is satisfied that the second entity is controlled by another entity that is not the first entity or the first entity's affiliates. I've just talked about connected entities. I'll now talk about the spouse or child under 18 affiliate rule. In broad terms, this rule operates where an entity owns a CGT asset. I'll refer to them as the asset owner. The CGT asset is used or held ready for use in the course of carrying on a business by another entity, and I'll refer to them as the business entity. and the business entity is not otherwise an affiliate of or connected with the asset owner. Where those conditions are met, we must retest whether or not the business entity would be an affiliate of or connected with the asset owner if a test individual's spouse and child under 18 years of age were taken for testing purposes to be the individual's affiliate. If a result, the business entity would become an affiliate or connected entity with the asset owner, then the business owner will be taken to be an affiliate or connected with the asset owner for the purposes of the small business CGT concessions. And the individual spouse or child is also taken to be an affiliate for the purposes of the small business CGT concessions, including for testing which entities are connected with each other. So that's it for this video. If you'd like to know more or get in contact, head on over to our website.